Hi everyone, Keith here. Hey, I've got some information I'm gonna go over with you today, and basically it's some general definitions and requirements of travel and restrictions of such travels, as well as a couple definitions. Um, we're going to start out with the right to travel, freedom of movement, um, methods and modes of locomotion, use of streets and highways. And it says, and this is from Bouvier's 1951. Um, it's actually called the right to travel. Um, says the constitutional right of individuals in the exercise of their liberty interests by claiming their right to travel in this writing is a 100-year-old concept as it relates to the introduction and evolution of the automobile industry and an individual's necessarily impetuous need to travel the common highways. As indicated herein, the highways were established for the use of the general public. Streets and highways are established and maintained primarily for purposes of travel by the public and incidental uses. And this comes from American Juris Second Highways, Streets and Bridges, section 227. Then it says the right of locomotion has also been held to be a part of the liberty guaranteed by the Due Process Clause. And that's specifically cited in the U.S. vs. Laub 385 U.S. 475, 87 SCT 574. And I'll post any of this if anybody wants it posted. I try my best to save everything I research. Then it says the United States Supreme Court has held that the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty. And this refers to the Constitution protects right to travel locally through public spaces and roadways. And there's some sites in here as well. I will post those or send them to you if you request. Then it says, a distinction may also be made between private carriers who transport their own property for compensation and those who transport their own property without compensation. Notice the use of private carriers. Doesn't and that means if you're conducting business, you can still be conducting private business. You do not have to be involved in a quasi contract where the government can come in and say, well, now we have a right to regulate your commerce. That's bullshit. So I'll start over. A distinction may also be made between private carriers who transport their own property for compensation and those who transport their own property without compensation. The use upon the public highways of motor vehicles engaged in transportation for hire may be prohibited, restricted, or conditioned by the controlling public authority. Highways are public avenues for use by the entire public for their private and personal purposes, and the use of a highway for profit and gain may be restricted. And that's cited in Stephenson versus Binford 287 U.S. 251, 53 SCT 181. Then it says, improved methods of locomotion are perfectly admissible. Public rights do not depend upon the methods of travel recognized at the time the streets were opened, or such public uses as have been sanctioned by long continued custom and acquiescence. The use of the streets must be extended to meet the new needs of locomotion. And then it says, and again there's publication cited there, In all human activities, the law keeps up with improvement and progress brought about by discovery and invention, and in respect to highways, if the introduction of a new contrivance for transportation purposes is conducted with due care, the contrivance is compatible with the general use and safety of the road. In other words, when they made these laws for travel back in 1851, and there was no such thing as a vehicle yet. It was by horse and buggy. Now that somebody invented a vehicle or an automobile or different, more modern mode of transportation, of traveling, then it includes that. So if in the future somebody designs a hover car, guess what? It includes that right to travel too. Gee, don't we have hovercrafts? Included in the right to travel. Everything of the invention and discovery according to the times. Then it says the right to travel is a right applicable to intrastate as well as interstate commerce. Inasmuch as the right to travel is not based on the Commerce Clause, it does not depend on the interstate nature of travel. Rights such as the right to travel, which involve personal liberty, are not dependent on state lines. Both travel within and between states is protected. So in other words, if you read into that correctly, when you're traveling through Nevada and you live in Iowa, and all those states in between, they have their own different plates and registration forms. And when a nice policy enforcer pulls you over because you've got an out-of-state plate, he is committing an offense against the federal rules and regulations. As this states, the right to travel is a right applicable to intrastate as well as interstate. And just because you have different plates does not give them a right or a privilege to over or supersede your right to travel. Period. It's a perversion of the words, and if you don't get out of this damn cognitive dissonance and learn this stuff for yourself. Hey, I'm putting it out there. I'm reading it from their books. If you want to learn it, read it yourself so you know it. Don't just believe me. I've said this before. Don't believe me just like you wouldn't believe them. I'm giving you the sources. Read it for yourself so you know it. Get beyond this system of beliefs. B-E-L-I-E, lie, F-S. Then it goes, and of course, again, it gives more references, cites more references. Then it says, quote, complete freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet, under an act like this, arbitrarily administered, the highways may be completely monopolized. If through lack of interest the people submit, then they may look to see the most sacred of their liberties taken from them one, by more or less rapid encroachment. In other words, what I just said, if you're going to believe and not find out the facts and the truths for yourself, then you're just submitting, and you're through lack of interest, through lack of self-interest, you're just believing somebody else. You're going to lose those liberties. You've already lost them if you're involved in that cognitive dissonance and you just believe that they can subject you to their inane bullshit. The public roads have been monopolized by a foreign military state police. And these are quotes right from The Right to Travel, Bouvier's, Black's Law Dictionary, first edition, fourth edition, ninth edition. You can look all these terms and stuff up and verify them. Verify them. Verify them in their own publishings. So I'll start again. The public roads have been monopolized by a foreign military, state police. The most sacred of liberties, of which Justice Tolman spoke, is personal liberty. The definition of personal liberty is, quote, personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from or dependent on the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as a right to private property, and is regarded as inalienable. In other words, the Constitution doesn't give us the right to travel. We have that right by our Creator. He gave us limbs for a reason. He did not mean us to be sitting as blobs. He gave us limbs and the freedom of movement. And this is according to the 16 Corpus Juris Secundum, Constitutional Law, Section 202. It's right there in their own publishing. Then it says, the concept is further amplified by the American Jurisprudence Encyclopedia, first edition. Personal liberty largely consists of the right of locomotion, to go where and when one pleases, only so far as restrained as the rights of others may make it necessary for the welfare of all other citizens. In other words, my movement is unrestricted unless it entails prevention of somebody else's rights. I cannot infringe upon another man's rights if I expect my own rights to be upheld. The right of the citizen to travel upon the public roadways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his life, or his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. 11th American Jurisprudence, first, Constitutional Law, Section 329. And further, personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint, unless by due process of law. Bouvier's Law Dictionary, 1914th edition, Black's Law Dictionary, 5th edition, Blackstone's Commentary, 134, Hare Constitution, page 777. Justice Tolman was concerned about the state prohibiting the citizen from the most sacred of his liberties. And remember here, it uses the word citizen. And I want you to understand, this is in accordance with the states not being able to supersede your federal rights. Same goes for citizen. It applies to any man, any person. A man has higher standing than a citizen. A man, a sovereign man, has higher rights or higher standing than any citizen. If they want to uphold these rights for a citizen, stand up as a man if you're not a citizen, and make sure that they protect you as well. They're in accordance with every man, woman, and child on the planet. Period. we're going to start again. Justice Tolman was concerned about the state prohibiting the citizen from the most sacred of his liberties, the right of movement, the right of moving oneself from place to place without threat of imprisonment, the right to use the public roads in the ordinary course of life. When the state allows the formation of a public corporation, business, it may control its creation by establishing guidelines, statutes, and charters for its operation. Companies that use the roads in the course of business do not use the roads in the ordinary course of life. In other words, your state police, your state troopers, anybody who is employed by a corporation has not the standing that I have as a man. Period. Because they're not doing it in the course of life, they're doing it in the course of corporate business. Therefore, these state codes and statutes and regulations apply to them, not me. There's a difference between a corporation and an individual. The United States Supreme Court has stated, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. In other words, that's where you get the burden of proof. When you want them to clarify that that state code or statute applies to you, they have to prove it. The individual may stand upon his constitutional right as a citizen. Now here, again, it says citizen. But the individual, which means the individual man, the individual person, the individual citizen, the individual employee, whoever it is, he is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or his neighbor to divulge his business or to open his doors to investigation, so far as it may tend to incriminate him. So far as it may tend to incriminate him. In other words, their definition of incriminate him by their state codes and statutes. They have to prove first that I am applicable to their state codes and statutes before they break my window out of my fucking truck again. Period. Prove it. That's due process. He owes no such duty to the state, since he receives nothing therefrom, quid quo pro, beyond the protection of his life, liberty, and property. I'll read that again because I added that quid quo pro. That's what that means, since he receives nothing therefrom. You want something from me? Give me something. Quid quo pro. So, he owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of the law, and in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under warrant of law. He owes nothing to the public, so long as he does not trespass upon their rights. Further, upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is this reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not, in exercise of its sovereignty, inquire how those franchises had been employed, and whether they had been abused, and demand the production of corporate books and papers for that purpose. And this one specifically is cited, Hale versus Hinkle, 201 U.S. 43. So, when it comes to your right to travel, understand, no one has the right to infringe upon that, period. 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 No one. No man, no person, no citizen, no corporation, no entity, no judge, no nothing, unless there is a warrant, a grand jury indictment, or a verified witness to a crime. Period. Now we're going to get on to Black's Law and Bouvier's Law dictionaries in regards to a couple definitions. Black's Law, first edition, and I'm using a couple words in here to point out the perversions of the words as time goes on. And this one here particularly, Black's Law, we're talking about ignorance. Black's Law, first edition, ignorance, the want or absence of knowledge, unaware or uninformed. Ignorance of law is want of knowledge or acquaintance with the laws of the land so far as they apply to the act, relation, duty, or matter under consideration. Ignorance of fact is want of knowledge of some fact or facts constituting or relating to the subject matter in hand. Ignorance is not a state of the mind in the sense in which sanity and insanity are. When the mind is ignorant of a fact, its conditions still remain sound. The power of thinking, of judging, of willing is just as complete before communication of the fact as after. In other words, just because you're ignorant and don't know something doesn't mean you can't find out. The essence or texture, so to speak, of the mind is not, as in the case of insanity, affected or impaired. You can still find out. Ignorance of a particular fact consists in this: that the mind, although sound and capable of healthy action, has never acted upon the fact in question, because the subject has never been brought to the notice of the perceptive faculties. Synonyms are ignorance and error or mistake, and they are not convertible terms. The former is a lack of information or absence of knowledge, the latter a misapprehension or confusion of information, or a mistaken supposition of the possession of knowledge. Error as to a fact may imply ignorance of the truth, but ignorance does not imply error. General types. Culpable ignorance is that which results from a failure to exercise ordinary care of acquired knowledge, and knowledge which could be acquired by the exercise of ordinary care is by law imputed to the person, and he is held to have constructive knowledge. In other words, ignorance of the law applies to those who know the law and practice the law. Ignorance of the law is applied to those that are applicable upon that law. In other words, if you're working for the state and those laws apply to you, and you want to sit there and say that ignorance of the law is not an excuse for me, bullshit, it isn't. Ignorance of the law is no excuse for you. You want to sit on that damn bench on a different plane than me and profess that you're greater than I. Bullshit. 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 You're supposed to know the law better than I. So when my ignorance, the want for knowledge of the facts, comes about, and I do my research and I find this stuff, beware, beware, beware. You have trespassed me. Essential ignorance is ignorance in relation to some essential circumstance so intimately connected with the matter in question, and which so influences the parties that induces them to act in the business. Essential ignorance is ignorance in relation to some essential circumstance so intimately connected with the matter in question, which so influences the parties that induces them to act in the business. The business. The business. All crimes are commercial. So when you want to pull me over, even though I clearly described my private property as private property and induce me into your business, your essential ignorance is so intimately connected with your duties that somebody else tells you to do for compensation. Beware, beware, beware. Your ignorance of the law is no excuse either, Mr. Aaron Haas. Involuntary ignorance is that which does not proceed from choice, and which cannot be overcome by the use of any means of knowledge known to a person and within his power, as the ignorance of a law which has not yet been promulgated. In other words, if you want to presume something because somebody is trying to enact something in the legislature and that someday it will be verifiable or viable, doesn't mean you can hold me to it now. Doesn't mean that you can hold me to a law or state statute that already exists when I'm not applicable to it. That's your involuntary ignorance. And then we have non-essential or accidental ignorance, is that which has not of itself any necessary connection with the business in question, and which is not the true consideration for entering into the contract. And remember, this is Black's Law first. Non-essential or accidental ignorance is that which has not of itself any necessary connection with the business in question, and which is not the true consideration for entering into the contract. Now we got voluntary ignorance exists when a party might, by taking reasonable efforts, have acquired the necessary knowledge. For example, every man might acquire a knowledge of the laws which have been promulgated. So, when you're practicing law, and you've gone to these Ivy League colleges, and you've studied law, and you've got these years of education, don't take upon a voluntary ignorance. Beware, beware, beware. Now we got Black's Law first in regards to, I tried looking up idiot, but it's not there. It comes up idiota, the same word with an A on the end, and it says idiota. In the civil law, an unlearned, illiterate, or simple person, a private man, not one in office. A private man, not one in office. And then we go for the perversion of the word. We go all the way up to Black's Law 9th. And it says, idiot. And it's spelled I-D-E-O-T. Not I-D-I-O-T, I-D-E-O-T. An old form of idiot, I-D-I-O-T. So somewhere along the line, they did not include idiot in the first Black's Law Dictionary, and instead made it idiota. So we're going to do some researching there and find out the etymology of the word idiot. And I'm sure it's going to include both of those. Idiot, idiota, idiot. And it says, idiot, I-D-I-O-T, a person who has been without understanding from his nativity, and whom the law, therefore, presumes never likely to attain any. The law presumes never likely to attain an understanding of his nativity. So, And then here it says in Black's Law, idiota, in civil law, an unlearned, illiterate, or simple. I must have missed something there. I have to look that up here. Let's see here. What's it say for idiota? In civil law, an unlearned, illiterate, or simple person. Calvin, a private man, not one in office. Pretty much the same as Black's first, but it includes a word here, Calvin. So let's look up Calvin. And where we get to Calvin, hold on just a second here. An awful big, it doesn't say, it says Calvin's case. Calvin versus Smith. Decided in 1608, in which it held that persons born in Scotland after the accession of James I to the crown of England in 1603 were not aliens, but were capable of inheriting land in England. We'll have to check that out again. But anyway, so we get back to Bovier's now in regards to idiot. Bovier's 1856 edition. Idiot, persons, a person who has been without understanding from his nativity, and whom the law therefore presumes never likely to attain any. Sounds almost like the exact same thing as Black's Law. And then we go to voluntary ignorance. Involuntary ignorance. Involuntary ignorance is that which does not proceed from choice and which cannot be overcome by the use of any means of knowledge known to him and within his power, as the ignorance of a law which has not yet been promulgated. Same thing again as Black's Law. And then we get to ignorance is either essential or non-essential. Essential ignorance is understood. Wait a minute, let me see here. Let's go directly to here. Ignorance, the want of knowledge. We're going to read this off. Ignorance is distinguishable from error. Ignorance is want of knowledge. Error is the nonconformity or opposition of our ideas to the truth, considered as a motive of our actions. Ignorance differs little from error. They are generally found together, and what is said of one is said of both. Ignorance and error are of several kinds. When considered as their object, they are of law and of fact. When examined as to their origin, they are voluntary or involuntary. When viewed with regard to their influence on the affairs of men, they are essential or non-essential. And that's why you get all those different things of ignorance in the Black's Law Dictionary, and it's going to discuss them here as well. It says ignorance of law and fact. Ignorance of law consists in the want of knowledge of those laws which it is our duty to understand, and which every man is presumed to know. The law forbids anyone to marry a woman whose husband is living. Therefore, if any man imagined he could marry such a woman, he would be ignorant of the law, and if he married her, he would commit an error as to the matter of law. Ignorance of fact is the want of knowledge as to the fact in question. It would be an error resulting from ignorance of fact if a man believed a certain woman to be unmarried and free, when in fact she was married woman. And were he to marry her under that belief, he would not be criminally responsible. Ignorance of the laws of a foreign government or of another state is ignorance of a fact. So, when you have ignorance of the laws and you practice the law, that's where ignorance of the law comes in as no excuse. Ignorance of the law in regards to me as a foreign state, because I am not a citizen, I am not a person, I am not employed, I am not under any contract with any foreign entity, means my ignorance of the law is in truth just that and nothing more. It says ignorance is either voluntary or involuntary. It is voluntary when a party might, by taking reasonable pains, have acquired the necessary knowledge. For example, every man might acquire a knowledge of the laws which have been promulgated, and a neglect to become acquainted with them is therefore voluntary ignorance. In other words, if I wanted to, I could go through the 800,000 plus state codes and statutes and be no longer ignorant of them. But then you also have all the different states. So if I wanted to go from Iowa to, say, Florida, I would have to learn all the state laws along the way as well. I can do that. But that is my excuse. If you're a, quote, funny clown in a black dress calling himself a judge in the state of Kentucky, and I come traveling through your state, don't be ignorant of your laws, because I'll find them and I'll throw them right back at you. Involuntary ignorance is that which does not proceed from choice, and which cannot be overcome by the use of any means of knowledge known to him and within his power, as the ignorance of a law which is yet be promulgated. In other words, if they haven't wrote it yet, you can't be ignorant of it. It's involuntary. Ignorance is either essential or non-essential. By essential ignorance is understood that which has for its object some essential circumstance so intimately connected with the matter in question, and which so influences the parties that it induces them to act in the business. Again, there's that word business. For example, if A should sell his horse to B, and at the time of the sale the horse was dead, unknown to the parties, the fact of the death would render the sale void. Non-essential or accidental ignorance is that which has not of itself any necessary connection with the business in question, and which is not the true consideration for entering into the contract. As if a man should marry a woman whom he believed to be rich, and she proved to be poor, this fact would not be essential, and the marriage would therefore be good. So, when it comes to all these terms and definitions and everything, you need to get in there and understand them. You need to learn them in regards to your own situation so that you quit believing. Be-lie-ving. That's what it is. They're lying to you. Lie, lie, lie. You want to be cognitive dissonant? Then be a cognitive dissonant. It's your own ignorance. It's your own voluntary ignorance. Quit it. You want to stand up for something, then start doing this stuff. People on this damn internet running their mouths all over the place and this and that. If you're not taking action, then you're just running your mouth. That's all it is. Me personally, I'm involved in a current case. I've got a 151-page document I'm getting ready to enter into the Supreme Court of Iowa. And I'm doing all the investigation I can in order to throw these words right back at them, shove them down their goddamn throat. Because they aren't my words. And for those out there that want to sit there and tell me I'm posting bogus shit, my apologies if my ignorance hasn't proven the proper way. But I only post what they post. It's in their own damn books. So if you want to tell somebody it's bogus, tell them it's bogus. Tell somebody else it's bogus. Those people that are using these UCC1s and want to do this status correction, go ahead and do it. My status is already correct. Very simply, I'm a man. That's my status. Remember the first two rules of commerce, people. You can only control, the first one is you can only you control only that which you create, and you cannot control that which you do not create. You can control only that which you create, rule number 1, and you cannot control that which you did not create, rule number 2. So when you want to dive into those UCC1s and take control of that straw man, remember, you did not create it. Just pointing it out, people. I think you're on the wrong path. I know there's ways that people have been proving how to do it, but I think that's all part of the cognitive dissonance. You're involving yourself in their system and perpetuating the person and the citizen and the statutes and everything of a corporation, and you're being part of that corporation. I love you all, though. We all have the same rights, no matter whether you're a citizen, a person, whatever. The difference is that when you take upon that persona of being a person or a citizen or an employee, you're relinquishing your rights for those privileges. I wish you wouldn't. All man is created equal. It's the documents that man creates afterward that makes you not. When you start signing your name. Remember, signing in cursive is a curse upon the document you're signing. God bless y'all. I love you. Have a great day.